We're going to dig in today on what we're hearing from our contacts in Washington. Those of you who know us well know that we have been active in Washington and continue to maintain strong contacts with both members of Congress and lobbyists working with them. But overall, I think we have to say that the members of Congress recognize this inconsistent legislation and changes is not good for economic development. While both the legislation and the regulation changes are outside of LCR's control, it's important to us to communicate the best we can what we know and what we believe is happening in order to help our clients feel comfortable in their decisions and make any choices they need to make. We, of course, remain optimistic and hope that we'll be able to look back at this summer as a time of frustration and delay, but not one that stopped our goal of helping people like yourselves move to the United States. So a couple of housekeeping points. We are recording today's session. I think you heard that just come across and probably had a notification on your screen. We will make this recording available to all of you and to people who registered who weren't able to attend. Second, we are planning on taking questions. So I already see some questions have come in through the Q&A functionality in Zoom. Please use that rather than the chat functionality. We'll watch both, but if you could use the Q&A functionality, that's the easiest for us to work and manage the process as we go along. Suresh, would you like to introduce yourself to the members in the audience?
Sure, thanks, John, appreciate it. Good day, everyone. Thanks for making the time to join us. My name is Suresh Rajan. I'm the founder and executive chairman of LCR. By way of relevant background, my professional career actually started in Washington, D.C. I worked on Capitol Hill and from 1988 to 95, both as a staffer and later as a lobbyist. Launched LCR in 2012. Obviously, we became very active in EB-5 around 2015 and 16, and we had I think over the last 2 or 3 years alone, a tremendous amount of growth globally, which I think is representative in the client and attendees for this call. Matt Virkstis and I lead the company's efforts in Washington, representing both LCR and the EB-5 industry in what ways we can. And we're looking forward to sharing what we know to this group today.
Matt?
Hi, everybody. Thank you, John. Yes, my name is Matt Virkstis. I'm the Chief Compliance Officer and General Counsel for LCR. I've been with the firm since 2017. Prior to joining LCR, I've spent the majority of the early part of my legal career for about 9 years as a senior counsel to the Senate Judiciary Committee, where I had the opportunity, among other things, to work on the EB-5 program. And so I watched the program from the policy side, from 2005 up through 2014 when I left, and experienced the tremendous growth on the congressional side and watched it sort of blossom into what it is today. But like Suresh said, we'll be happy to share what we can and what we know about what's going on in Washington. We remain optimistic, and we'll get into more of that as we get through the webinar. Thank you, John.
Thank you, Matt. So before we dive in, I do need to make a few of the standard disclaimers. I think everyone who's been on our webinars in the past knows that the EB-5 visa is based on an investment, but this is a marketing presentation and doesn't constitute an offer to sell securities. If you're interested in seeing project investment documents, we ask you to contact us directly so we can confirm you're an accredited investor or the equivalent in your market. We can also then focus the conversation on your individual needs or family needs. Equally, for existing clients, we are going to be discussing areas of immigration law and federal law, but of course, none of this conversation or QA can be considered legal advice. You'll need to reach out to your attorney directly. Obviously, you have a client-attorney relationship there to receive legal advice. And of course, we always make ourselves available to our clients for one-on-one questions to discuss your individual situation. So let's turn to our program today. We're going to start by looking at the current situation. We've had a number of conversations with people who, as I mentioned in my introduction, aren't following as closely. So there'll be a little bit of a rehash of what the current situation means for individual investors. We're also then going to turn to the different reauthorization pathways, the vehicles in to produce new legislation, and we'll talk a bit about regulation. We will discuss investment levels, impact on filed clients, and again, I already see a number of questions coming in. We'll look to address those as well. We're going to reserve some time for Q&A. So where are we in the Regional Center program with EB-5? So the program has lapsed as of the end of June, and because of the Bearing Court case, as I mentioned, the federal courts struck down the 2019 regulations that changed the investment level from 500,000 to 900,000 and changed some of the TEA and other provisions in the regulation. Equally, because of COVID, there have been delays in consulates and in the USCIS processing of petitions or adjustment of status applications. Because of the lapse, new petitions are not being reviewed, and equally, adjustment of status for people who haven't received a conditional green card are not being processed. That's a very top line summary. Matt, I was wondering if you could just go through, because we have a number of clients on the call, and talk about the different statuses of people and what this lapse and the regulation change means to them.
Sure, John. So let me just back up and provide a little bit of context. Many folks may be aware of this, but I think it bears repeating that it's important to recognize that the EB-5 program broadly in the federal law is made up of two components. In 1990, I believe it was, the Congress enacted the regular direct EB-5 program. That's a permanent program, and it's distinct in a number of ways from the Regional Center program. A couple of years later, as I understand it from the congressional history, the legislative history, Congress enacted the Regional Center program in 1992, became effective in 1993 as a pilot program. And the idea behind the Regional Center program was to increase the interest among foreign nationals to invest in the U.S., to immigrate through investment to the U.S. by permitting individuals to pool investments into a single project. So they did a number of other things that were intended to increase interest in the program. And indeed, a decade later, I think that very much was borne out by the history. But for a number of reasons, and I don't really know what they are, probably it boils down mostly to congressional inertia, the Congress never made the Regional Center pilot program permanent. It was reauthorized over the years. I don't know the number off the top of my head, John, you might, but a dozen plus times in varying degrees of length. Most recently was reauthorized up through June the 30th of this year, as John mentioned, is when it lapsed. So to be clear, there is a portion of the Regional Center program that remains, a permanent part of the federal immigration law. It's the Regional Center program that we're discussing today that the vast majority of investors invest through in EB-5. And so I just wanted to provide that context for people who may not be aware of the distinction and what we're talking about when we refer to the Regional Center program. I would say as a caveat to anybody who's interested in finding out the most current and relevant information related to this way that the immigration agency here, which is a sub-agency of the Department of Homeland Security, which is called the U.S. Citizenship and Immigration Service. Anybody who's in the process knows that sub-agency well. That is the sub-agency that administers the program, and people should consider the agency website, and we can certainly post a link in the chat. John, I'll do that if I get a moment, but for news about the way that the agency is treating petitions through the Regional Center program, or what it plans to do, or what its expectations are, process, etc., people should rely really only on what the USCIS is putting out on their website for current and relevant information about what the administering agency is going to be doing. With all that said, the agency did put out some guidance shortly after the program sunset, and it was consistent with guidance that the agency put out in prior instances where the program lapsed. So I'll sort of start from the top here. If you have a pending, well, I'll back up even further, excuse me. the agency currently is not accepting I-526 petitions submitted under the regional center program. So if an individual were to try to submit a regional center-based I-526 petition, the agency has indicated that that petition would simply be sent back. It will not be receipted at the intake center at one of the processing centers. If you have a pending I-526 petition, the agency has said that those petitions right now are being held in abeyance. And what that means is that the agency does not have the legal authority to continue to adjudicate those petitions that are predicated on a regional center investment. And so they simply can't act on them. They don't have the legal authority to do so. But instead of simply sending all those petitions back, the agency is taking the view at the moment and assuming that Congress will reauthorize the program. And because they are taking that position, the agency has decided to simply hold these petitions, stop work on them, but they're not sending them back. So I think that's a very important point to make, because as in past lapses, the agency's assumption was borne out correctly, and Congress did in fact reauthorize the program. At least two, I think there were two lapses. One may have been related to a government shutdown, but there was one early in the early 2000s where there was a lapse, and then Congress reauthorized it legislatively, and things continued. So again, if you have an I-526 petition pending, as you're probably all painfully aware, the agency is not currently working on those petitions. If you have your conditional green card, the good news is that because the process in the law by which the agency and the State Department, if you have a visa that's been issued, it's conditional green card, so you're in your 2-year sustainment period. At the end of your sustainment period, you may still file an I-829 petition. The reason being is that the I-829 process that's laid out in the Immigration and Nationality Act is a permanent part of the law. And so the view from the agency, which is, I think, an absolutely correct one, is there is no bar to the agency processing an I-829 petition to remove your conditions on your green card. Whether you've come through the direct EB-5 program or the regional center program, that's water under the dam as far as the agency is concerned, and they do have the authority to continue adjudicating an I-829 or to take up a new I-829 petition. So that's a good thing. So if people are through the I-526 process, have a conditional green card, this lapse really does not affect someone in that status. Currently, the government is not doing adjustment of status petitions or consular interviews. It's sort of been a double whammy, I know, for people who've been waiting consular interviews between COVID and then the lapse in the program, and understand that that's extremely frustrating. But the reason being is that that adjustment of status, whether through domestic AOS or a consular interview, are predicated on the regional center I-526, and so the agency has taken the view that they do not have the authority to continue that process. So again, if you have an I-526 pending, work has been stopped on it. If you are in the I-829 phase, the agency can continue working. So John, let me stop there. I know that was a lot of information all at once.
No, it's information that we know a lot of our attendees are interested in hearing. So if you have filed and you've received a receipt, you won't move forward until the program is reauthorized. If you have received your conditional green card, you have a standard path towards having those conditions removed, and even in a few years, if choosing, you can apply for citizenship. Excellent. So the second big question we keep receiving is, what does this mean for the investment? So Suresh, clearly, when people talk about a lapse in the program, people start to ask, does this put the capital I invested at risk? Is there a chance that I will lose that capital? Can you talk to that?
Sure, of course. Yeah, a very important question on the minds of many. To be clear, this is a clear distinction between an immigration issue and an investment issue. The lapse in the program is a lapse in the immigration process of our investors and others. The projects themselves are sound. The LCR projects that are based throughout the U.S. in a handful of states have been performing exceptionally well. especially in light of the pandemic. I think we were very pleased to see that our developer partners were able to weather the storm, as it were, and have been performing at an exceptional level. I think a lot of credit also goes to the U.S. government for their very proactive steps fiscally to assist the country's economy in stabilizing over the last 18 months. I tell a lot of clients that the U.S. government stroked a $4 trillion stimulus check essentially to bolster the economy and keep it where it is. And that's a kind of credit enhancement that's not part of any offering document, but is indicative of the safety of an investment in the U.S. So the projects are doing very well, performing very well. This is an issue on the immigration side, which is just as important to our clients and to LCR. But that's where the focus is. The concern shouldn't be on the investment itself.
So that is a relief, obviously. Not that we don't underestimate how important the immigration benefit is. That's why we've all been working on this and pushing it forward. So the concept of abeyance, Matt, clearly the agency in the Department of Homeland Security and the USCIS has a decision point. They'll hold things in abeyance until they believe Congress has made a decision not to renew the program. Are there any indications that, in fact, the agency believes, what have they done that indicates that they do believe that the program will be reauthorized?
It's a good question. I will say we're in uncharted waters here to some extent. I don't know. I mean, to your first question, what would trigger USCIS to believe that the Congress was not going to reauthorize the program? I am not quite sure what that would be. It could be a formal message from the Congress or a committee, the authorizing committee, which is the Senate Judiciary and the House Judiciary Committees that oversee the Immigration and Nationality Act and immigration policy. It could be a formal statement from those committees or the chairman and ranking members of those committees to the DHS. I find it sort of hard to believe as a political matter that anybody would want to take credit for ending the EB-5 program. So that seems sort of hard to believe. But again, I don't have a good answer for that because we're a bit in uncharted territory here, and I'm not quite sure how what would trigger the agency to take that position. To the second part of your question, I'll give credit to Suresh for this observation, but the fact that the USCIS has indicated to the Ninth Circuit Court of Appeals that it intends to appeal the Bering decision in the Ninth Circuit certainly suggests, and I think it's a reasonable inference to draw, that the agency thinks that the program is going to be reauthorized. They seem to care about their regulations that were put into place in November 2019. They have made it clear through their court filings and through other statements from executive branch officials that they like those November 2019 regulations, and they appear to be fighting for them. So that I think I think it's a reasonable inference to draw from that. It seems to me to be a reasonably strong statement from the government that they think Congress is going to get its act together and reauthorize EB-5. So I think I think it's a positive takeaway. Putting aside what anyone may feel about the regulations, I think it's somewhat of a positive sign that the government is taking that position with respect to the regulations. So,
and an application is still current. It's still in process until the agency actually sends a notice otherwise. They would need to return the application effectively.
Yeah, I mean, I'm speculating here, but I think if we got to that sort of worst case scenario, the USCIS would put some sort of a public statement out on its website advising attorneys of record and petitioners about what their view was and how it was changing and what they planned to do before they did it. I think they wouldn't just start sending people's petitions back with no explanation. I think that would be, executive branch malpractice. USCIS, after all, is a customer service agency post 9/11 when the DHS was organized, and ICE and the enforcement arm of the immigration function in the U.S. government was separated very purposefully From the benefit side of the immigration function of the government, USCIS was set up very much with the intention for it to be a customer service agency. It's a fee-for-service agency, and my guess is that that they would give notice to all of the stakeholders about what decision they were taking.
Excellent. So turning to the push for reauthorization, Suresh, as you look across Congress, where do you see the most sort of proponents or the people that are active discussing it, their staffs, in terms of reauthorization?
Sure. So the program certainly needs the support of both houses of U.S. Congress. That's the House of Representatives and the Senate. But to be sure, the Senate has really led the efforts here on the program over the years. The Senate Judiciary Committee and the ranking members of those committees. Before the change in control from Republicans to Democrats, Senator Grassley out of Iowa and Senator Leahy out of Vermont were the principal leads from the Senate Judiciary behind the program. They've provided a lot of support over the years. They drafted a very investor-oriented integrity bill that unfortunately missed by one vote to become law just this past summer. But those are the committees that are very important to the program. But the nuance that's, I think, as important, perhaps more important, is who actually is impacted by the program from an economic standpoint. And while there's EB-5 investments across the country, there are gravity centers of where that money is invested, places like New York, Florida, Texas, California. So these are states with very strong representation in Washington on Capitol Hill, both Democrat and Republican, House and Senate. The Senate is run by Senator Schumer from New York, who is the single biggest supporter of the program, largely because his state benefits more than others. But that's what he's there to do, is to represent the interest of his state. So he has been a staunch supporter over the years. On the Republican side, it's really led by Senator Cornyn out of Texas, and that's where LCR has made a lot of investments. The senator has been working closely with Senator Schumer over the years to support the program and to grow the program. Both of those individuals have indicated a strong continuing support and have made public indication that they will work to try and get the program back on track. It's just too important not to. A lack of action by Congress is not something that's particularly palatable to anybody, including those that might actually oppose the program or not be fans of immigration. To pull the plug on critical funding of job-creating real estate projects more than anything else across the country is not something appetizing coming out of a pandemic and economic stress, and going into another election year in 2022. So there are a lot of individual pieces that suggest, look, everyone's got to get on the same page ultimately and figure this out. Of course, doing that in a timely fashion has always been a challenge, but there is no shortage of advocates on Capitol Hill for the program.
And within the industry, the key players that are advocating, I mean, obviously, we've done a lot with IIUSA, Invest in USA. Can you talk to some of the other people that are pushing the staffers to take up the subject?
So Invest in USA, IIUSA, is the leading industry association led by Aaron Grau, who's done a fabulous job representing the interest of not just the industry, but investors. Another group that also represents a big part of the industry is EB-5IC, the EB-5 Investment Coalition. And of course, there are others that are involved. I will say that all of these entities have contributed a lot in terms of their efforts to get experts to weigh in and influence the outcome, working closely with members, closely with staff, and closely with each other to accomplish that. I think as important are major players in the industry, firms like LCR that have a long-term commitment in the program are investing to make sure that the program is not only continued but improved and grown. LCR, like others, have hired their own specialists, lobbyists, political consultants to weigh in. LCR, for example, has done that with multiple firms that have strong interest in relationships on both sides of the aisle and on the House and Senate side. So there is a lot of separate forces at play at the industry level in conjunction with advocates on the Hill to, again, get the program reauthorized and grow the program going forward. So a lot of advocacy is happening quietly in the background.
And even with the legislation that's going through, which we'll talk to about a second, I mean, these are huge numbers. You know, the 3.5 trillion in terms of a reconciliation bill, the 1.2 trillion that's been proposed for infrastructure. You know, we're able to get congressional staff time. Meetings are happening. Yes, it's an important point. It has taken a bit of time to do that, but John, what you're pointing out is crucial. The EB-5 program, in its entirety, since the early 90s, has brought in, around $50 billion of foreign direct investment monies that aren't borrowed by from U.S. taxpayers or debt providers. But in comparison, it's trying to find time on the Hill from those folks that are working on multi-trillion-dollar vehicles that have to be agreed to in a relatively short time. So this is a very difficult time to get a lot of attention on something that even the staffers and members might find very important. The fact of the matter is there's just limited time, what they call limited oxygen or bandwidth on the Hill to spend on this. So we've been waiting impatiently since the end of June for engagement. But I will say we've had more engagement in August than we've had in some time. And then I think the industry and advocates on the Hill are starting to spend the time required to get a resolution of this. So let's turn to those legislative vehicles. A number of questions have come in saying, what are the opportunities for EB-5 to be included? In the spring, we talked a lot about the bipartisan infrastructure bill. Investment in real estate often comes with investment in neighboring transportation and upgrades to grids and infrastructure in municipalities. Sorry to come back to you again, Suresh, but any thoughts on why EB-5 wasn't included in that infrastructure, the $1.2 trillion bipartisan infrastructure bill? Sure. As you know, John, I've had no shortage of frustration on this point. Back in February, I think LCR's view was early on that the infrastructure bill was a very likely and reasonable vehicle for program reauthorization and reform to piggyback on. I had continued hopes of that, as did many, going into the summer and going into late summer. The challenges for both bills are the fact that the U.S. system right now is so partisanized that every vote on every side is meaningful. And the margins for victory are very slim. The Senate is 50-50, Democrat, Republican. It's in Democratic control simply because the U.S. Constitution gives the tie-breaking vote to the vice president, which happens to be a Democrat. And so it's razor thin there. It's only a few votes less razor thin on the House side. And so in an effort to get alignment with on both of these bills, it was believed by leaders of the Democratic Party, and I think understandably so, unfortunately, that they limit the changes to the bill that are happening that normally would happen to something like this, attack on amendments, et cetera. So that was tabled. Now, could that be reopened and revisited? Absolutely. But I think the position they've taken as early part of August that they were going to limit the discussions to just the base bill and not consider tack-ons like EB-5 reauthorization as a reasonable, though unfortunate step. I do think that
that may reopen again as we close to the end of September and the beginning of October. But right now it is a difficult situation to get additional things tacked on to these massive $1 trillion bills.
Yeah, that's right. So, the bipartisan bill had a lot of press in terms of how hard it was to keep the two parties together and coming to an agreed piece. On the reconciliation bill, it was written in the Times this morning that obviously they can't lose a single senator. The Democratic Party can't lose a single senator. And in the case of the House, it's only 2 seats that they can't lose. They can afford to lose, and otherwise they won't be able to pass this through reconciliation. So you can understand how that there's a lot of negotiation going on there. The other vehicle that a lot of people have talked about is the one that is where EB-5 lived from '92 until just this past this year, which is in the omnibus spending bill. There's other immigration programs there. It's obviously a bill, legislation that is renewed every year for the funding of the government. People have asked about the omnibus spending bill, whether immigration can come back in there. And Matt, I know that given the amount of work that's going on these other 2 bills, we shouldn't be surprised that there's also talk about a continuing resolution, or effectively Congress saying, we're not going to address the full budget. We're only going to agree that the current legislation will carry on to a new deadline. Can you talk a bit about the continuing resolution process and how EB-5 could fit in there?
Sure. Yeah, and thank you, John. It's a good question. I think we've heard when folks talk about this, sometimes there's a little bit of confusion about how this works. Admittedly, the appropriations process in the U.S. Congress is complicated, and it's sort of a multi-step process with lots of different moving parts. So the way the Congress in the old days, the appropriation committees in the House and the Senate would pass individual appropriation bills, essentially providing money to the various agencies of the government. There's 10 or 12 separate appropriation bills in the regular order process. The committees and the subcommittees would pass and approve for full consideration in the full House and the full Senate. I guess about a dozen appropriation bills. Those bills dealt with discrete subjects. For instance, there was an appropriation subcommittee bill, or one part of the appropriations bill deals with funding for the Justice Department and the Commerce Department and scientific research, right? So the appropriations bills were broken into smaller parts with discrete funding targets within the executive branch of the federal government. In recent years, due to a variety of factors and just sort of changing norms in the Congress would start packaging all of these smaller appropriations bills into a big bill, which was referred in the parlance of the Congress as an omnibus appropriations bill. The omnibus appropriations bill would capture all funding for the entire federal government. And essentially it was a single bill that packaged up all of the smaller appropriations bills. And obviously that takes a lot less floor time in the House and the Senate to take up debate and pass those bills to keep the government running. The federal fiscal year runs from October 1st to September 30th. So it's not a regular calendar fiscal year. And so we have upcoming quite soon, at the end of this month, the end of the 2021 fiscal year. That requires that the Congress take up and pass some vehicle that will continue funding authorization to keep the federal government running. People may have heard in the past, there have been instances where there was a US federal government shutdown. What that means is that the Congress did not pass continuing funding authority for the executive branch upon the September 30th deadline at the end of the federal fiscal year. So that's a little bit of context here. So the government is currently operating under an omnibus appropriations bill. That omnibus appropriations bill authority ends on September 30th. If the Congress cannot pass or is not prepared to take up and pass a omnibus appropriations bill for the federal fiscal year 2022. What the Congress can do, and has done with increasing frequency over the past few years, is pass what's called a continuing resolution. And to be clear, all of the continuing resolution does is carry forward for a set amount of time the existing appropriations authority. So it doesn't make any policy changes to the appropriations from the prior federal fiscal year. It simply just extends the date of that authority to some date in the future. Congress uses the CR to give itself more time to debate and pass a new omnibus appropriations bill. And the reason that it does that is because if anybody's ever looked at an appropriations bill, you will see that there's a number of things in those bills that deal with policy and spending policy. So the Congress not only appropriates money, but it can put conditions on the way that money is spent, or it can put certain directives on the way that money is spent. We want the Department of Commerce to spend X dollars on research into, name your sector of the economy. And so the continuing resolution just carries forward. It usually, because they are generally short-term bills, they need to be passed quickly, and they generally need the agreement of everybody in the House and Senate. They typically are asked, they typically end up being very clean, quote, clean continuing resolutions, meaning that there's not really any extraneous material on the continuing resolution other than just carrying forward the date for the spending authority for the federal government. Now, we understand the Congress may be looking to pass a continuing resolution to give itself some more time to debate, the bigger appropriations bills for the coming federal fiscal year. It is certainly possible, and it has been done in the past. There's plenty of precedent for it, that the Congress could put an EB-5 regional center extension on the continuing resolution that it's currently considering, or what we expect it to consider here before September 30th. Because the EB-5 regional center program was contained in the current omnibus appropriations bill, there is no barrier, and it should not be a big surprise or something that would be a curveball for any member of Congress to see, some additional authorization language. And really all it would be in the continuing resolution is a reference to the section in the appropriations bill and a note that says the date for this authority is extended to whatever date the continuing resolution is set to end on. So it's absolutely possible as a legislative and practical matter for the Congress to include an EB-5 regional center authorization on the continuing resolution. The other thing, the other mechanism here that the Congress can certainly do is they could include EB-5 regional center authorization and policy in an omnibus appropriations bill. They, so long as they get agreement from the chair and ranking members of the Appropriations Committee and the Senate and the House leadership, they could successfully include, essentially a larger EB-5 policy bill in an omnibus appropriations bill. As of today, we're not quite sure what the timing, Suresh, you may have a comment on this. We're not quite sure what the timing is either for the CR or for the following omnibus appropriations bill for the coming federal fiscal year. That all should become more clear, I think, over the next week or so about what Congress intends to do with respect to spending authority.
Yeah, on that, there probably will be a situation where there's sort of multiple spending bills, both CR and then an Omni. There's a chance, given how much time and energy has been focused on these trillion-dollar infrastructure vehicles, that there's not enough time to consider so many other things, not just EB-5, but many other important matters that need to be discussed on Capitol Hill. So, I can certainly see a situation where there's a, quite literally a very short-term CR, and CRs can be as short as a day and as long as 365 days. But I could see a situation where there is a, say a 2-week CR after September 30th. And, that would tackle sort of the major standard items, which are significant that there would be little to no debate on. And then a bigger CR that handles what can be termed as anomalies. And these are things like funding for Afghan relocation or additional funding to fight the historic wildfires out west. And it could be, EB-5 reauthorization on top of it. That second CR will likely take us to some point in December, and probably the earlier part of December, at which point people will try and get things done ahead of the holidays and the new year. More likely than not, they will need more time than the early part of December, and I suspect they'll extend it to near the end of the year with an effort to do a full Omni or mini Omni at the tail end of the year. So it is a multi-step process. It could be. Certainly, there is a possibility that EB-5 just gets addressed in a CR early on, and that a month from now we're all in very good shape. But absent that, there are a number of other opportunities between now and the end of the year for EB-5 reauthorization to happen. Obviously, every month, a week, or day that it takes are painful and uncomfortable for all of us. But the opportunities there, but more importantly, I think the need to address it long term is apparent to every stakeholder and everyone that has a vote on the issue.
So let's bring it back to our clients and the people on the call. If there's a continuing resolution, whether it's 2 weeks or all the way out to the middle of December, or as we say, it can even go into next year, and it's just a reauthorization, so no legislation. What does it mean for clients that have filed? Matt, I guess, how would the agency then react to Congress saying that the EB-5 Regional Center program has been reauthorized until the date of December 15th, for example?
Yeah, I mean, my assumption would be that the agency would very promptly put out a notice on the website saying that the Congress has given it authority, has renewed the authority for it to adjudicate EB-5 Regional Center petitions. The agency would begin work again at the service centers around the country on I-526 petitions that have been pending or that are pending. And the agency would also begin accepting new I-526 petitions. I don't really see any other option for the agency if the Congress, even for a short period of time, reauthorizes EB-5 through a CR for the duration of that CR. I don't think the agency has any other choice but to continue its work on accepting new petitions and working on pending petitions.
So one question we see frequently, people ask, they have children that all of these delays have caused them to age beyond 21. As we said at the beginning, petitions haven't been returned. So is there any risk to their children who are older than 21 at their age not being locked?
No, I don't. Although I don't believe the agency has spoken specifically on this at this point, it would be inconceivable to me if the agency didn't take the position as a practical matter that the time that the EB-5 Regional Center program is lapsed is treated the same way for purposes of the Child Status Protection Act as a pending I-526 petition. So in other words, the time that the program's been lapsed, that they can't adjudicate petitions, that would just be included in that time frame prior to approval of an I-526 petition. So it should not, in other words, said another way, it should not, the federal government's lapse of the program should not count against people for purposes of age outs of minor children.
Yeah. And so for people that haven't filed, for investors, Suresh, you mentioned that a continuing resolution could include EB-5 with no changes in legislation, no changes in, and could be, say, even 2 weeks. What does it mean for investors looking at the program? Obviously, their investment level would be 500,000. Would it be they'd be able to get into the queue effectively during those 2 weeks until follow-up?
That's our understanding. So as Matt pointed out earlier in the webinar, the agency has filed notice of their intent to appeal the court's ruling from earlier in the summer. which means they have yet to actually submit the appeal. But the recognition that they are providing is they have acknowledged essentially the court's authority here to set aside the regulations. Any appeal that would be filed would likely not be reviewed very quickly. There's obviously a lot of backlog on the courts, even for critical state matters such as this. So we do think that if there is a program reauthorization, whether it be a couple of weeks or a few months, it will have to stick with what the courts deem was the situation back in June, which means things like the investment level would be rolled back to 500,000. The guidelines for securing TEA letters or renewal of TEA letters would stay at the state level and not be at the federal. So there'd be a series of things that would kind of go back to essentially, 2019. And this is obviously a very, attractive potential window for investors to consider. But to be sure, you'd have to be looking for opportunities that fit that description of the EB-5 program as of 2019, which I believe the industry participants are working hard to create those kinds of offerings should that window open.
Right, ourselves included. So let's we've got about 10 minutes. Let's just quickly take about 5 and talk about what the Department of Homeland Security and the USCIS can do in terms of regulations. They've indicated they would prefer to have the regulations, the modernization regulations passed in 2019 and then struck down. What in the rulemaking process, Matt, just quickly, how does it work for them in terms of resetting a new set of rules?
So
now that's a long conversation to try to do.
I mean, typically the rulemaking process is there is federal law that governs the way that the executive branch makes regulations. Regulations are creatures of statutory law. The statutory law authorizes the creation of regulations, and think about regulations as sort of filling in the gaps in a broader statute that governs air quality, something like that. So the government, typically an agency in the normal course of dealing, needs to put out they draft a proposed rule, they put it out publicly in the Federal Register. There is a certain amount of time set, 30, 60, 90 days for public comment. The public is allowed to comment on those regulations. The agency takes those comments under advisement and then has to respond to them. So they actually have to deal with them. And then through, it can be depending on how long the agency takes to review and provide responses to comment, the agency would then produce a final rule for publication, and that rule would become essentially the law of the land. But that's a bit of an oversimplification because there are other agencies involved, namely the Office of Management and Budget, which has a say in the publication of final rules that the government produces. So it is put sort of simply, it's a long and involved process that involves a good deal of comment, not only from the public but other areas of the government.
And I suppose we can't speak for the agency, obviously, but we also, using logic, can see why they're not publishing new regulations when the program is lapsed and when they're expecting legislation which could have significant changes. And there's been discussions about the way visas are counted. There's been discussions about opportunity zones and TEAs, obviously investment level at 500, 700, all these different levels. They would need to react to all of that with new regulation if that legislation were passed.
I think that's right. I mean, and in fact, yes. I mean, the simple answer is yes. If the law changes significantly, the agency would have to react. Oftentimes, the Congress will include in a piece of legislation a command to the agency to write regulations within a certain time period.
Right. Okay. So we've got about 5 minutes. There's been a host of questions, and I've been watching them as we've been going along, and I'm happy to say that we've answered quite a few of them. We'll also go through these and make sure that we can come back to people if there are ones we don't get to. I think there's obviously a big conversation about, what are if the program is not reauthorized. We had some people say, what's the worst case scenario? I think, Suresh, I'll have to ask you to take that one, which is, if the program, if there were that worst case scenario that Congress said we will not reauthorize the regional center program and all of these petitions were returned, what would you imagine would happen next? I mean, obviously there'd be risk of litigation. There would be what would happen, and what do you kind of envision would happen, and also what would it mean for an individual investor and their capital?
Yeah, John, good question. Certainly that Armageddon description is, I think, apropos here. Look, a shutdown of the program creates issues for all the current stakeholders, both individual investors, the industry itself, but just as important, perhaps more impactful at the local level. You will have projects around the country that are now don't have access to funding that they expected to have. That will not be an issue that they sit quietly on. They will go to their elected officials and speak about that. There will be a need for some projects to essentially stop and return capital to investors. That could certainly be a situation. There will be investors that understandably will be looking to exit investments because of shutdown of the program. All of this would lead to not just litigation. We've conveyed these thoughts to decision makers on the Hill, but the same is true at the agency level. So USCIS, they get their funding. It's a user fee funded agency. Not only will they lose their funding coming from the EB-5 program, which is significant, but on top of that, they're going to have to deal with thousands of lawsuits from individuals and from companies that are involved in the industry and lack the financing to defend those positions and stuff. So there's any number of event cascades that can happen and will happen, all of which are unattractive. But I think combined, it creates the quiet argument no one wants to talk about of why this has to be resolved in a different way. And ultimately will I think motivate the Hill to accomplish something that by and large has a broad agreement across the industry.
And of course, just to reassure people, none of that impacts the risk of the developers or the people we've loaned money to being able to return that capital.
That's correct. That's independent of everything that's going on.
Yeah. Okay. So we are at the top of the hour. I mean, Suresh, we have a number of clients on the call. Would you like to just close with any thoughts for our clients?
Sure. Again, I want to thank everyone for joining us today. I hope this session was helpful. We obviously are available to answer further questions. I will say this about LCR. During the last couple of years with the pandemic, the industry has not grown. It has been difficult to conduct business with no one being able to travel, and considering investment levels the way they are, it's not an easy decision without being face to face. Regardless, LCR has grown during that time. It has added new capabilities like wealth management and mortgage services capabilities, all of which I think is reflective of how we view ourselves in the industry, which is this isn't transactional to us. We intended to be there for our clients, not just for the near term, but for the long term. We expect to see the same going forward. We expect the program to be reauthorized, and we expect to meet the continued needs and developing needs of our clients. So certainly have faith in LCR. We're there for you. Have faith that this will work out. It may be a rough ride until it does, but there's just too many reasons why the program must be renewed and reauthorized to the benefit of the U.S. economy. And the industry is working very hard to accomplish just that, not just LCR, but the industry as a whole.
Thank you. And thank you all for joining us on this webinar. As I mentioned at the beginning, we have recorded it. We will share the link. We'll also go through the questions that you've asked in specifics, and particularly for clients, we'll look to come back to you. Again, we can only hope that we do get reauthorization. As I said, we're optimistic. And then this becomes sort of just another delay. There has been legislation presented which addresses both not only reauthorization, but improved processing times. And we are 100% behind things like improving integrity and improved processing times so that this whole experience becomes a much better one, and the US can stand for what it's traditionally stood for, being a good environment for business, a good environment for investment, and welcoming immigrants that add a lot to this country. Thank you very much, everyone.
Thank you. Thanks, John.
Thanks, everyone.